Okay, I'd like to welcome you all to our argument this morning. My name is Jackie Steele, and I am a county judge out of Manatee County in the 12th Circuit and one of the competition chairs, and I wanted to welcome you here for the argument today. Today is the final round of the competition that took place virtually for the 2021 competition season, and that took place in November. And we had schools from all over the country participate in that competition virtually. And the two teams that are here that you will be seeing arguing today are the finalists for this 2021 Earle Zehmer National Moot Court competition. So before going further, though, I do want to give a little bit of background information so that those of you who are here in the audience listening or watching will be able to know a little background information about the problem. This is a workers' compensation case for death benefits claimed by Jane Doe, the widow of John Doe, against his employer, Bankson County Sheriff's Office, for his death on March 21st of 2020 from acute respiratory distress syndrome due to COVID-19. John Doe was a 26-year-old firefighter, paramedic employed by the county sheriff's office. The job was a 24-hour shift every third day at the Coral City Fire Station. John was assigned to a rescue truck, Rescue 7, although he had to go on fire calls in any cases where people were injured as well. There were expected falls which caused injuries, heart attacks, strokes, that all required rescue service and transport to a hospital, usually Coral City Memorial. On March 8th of 2020, John was on duty when an emergency call came in on 911. He was to go to New Palms Community for a woman down call. This was a retirement type assisted living facility that John's grandmother actually happened to also be a resident at. John Wolf, battalion chief for the deceased, told all three of the firefighters that were sent out to this call on Rescue 7 that Anna Drucker, who was the fallen individual who they had rescued on March 8, had been diagnosed with coronavirus. Battalion Chief Wolf gave this testimony also at the trial. He told them afterwards to go home after they had assisted on the call, to go home and self-quarantine for 14 days, and he arranged for them to be tested for coronavirus. John Doe tested positive. John Doe had also visited his grandmother March 10 of 2020 at that facility. The Bankson County Medical Examiner, Dr. Wright, testified at trial, and he stated that his investigation showed that Doe had performed a rescue on March 8 of Anna Drucker, who was admitted to the hospital on March 8 with acute respiratory symptoms and a positive COVID-19 test. And she was transferred to the ICU, given appropriate care, but succumbed to the condition on March 17, and the cause of her death was acute respiratory distress syndrome due to COVID-19. In the final compensation order that is under appeal here today, the judge of compensation claims held the death of John Doe on March 21st was compensable. He awarded workers' compensation death benefits to Jane Doe at the maximum compensation rate for 2020 from March 21 of 2020, which was the death date, and continuing. The JCC found in the trial order that the claim was governed under Section 112.1815 Florida Statute, and that the claimant had established by a preponderance of the evidence that the death of John Doe on March 21st was by accident arising out of and in the course of his employment as a firefighter paramedic. So the questions before the appellate court today are whether Dr. Wright, the county medical examiner's opinion, was admissible pursuant to Chapter 440 Florida statutes, and whether John Doe's death is a compensable accident or injury under either or neither of three potential statutory provisions: 112.1815, which was the underlying trial court's decision, 440.02, 1, subsection 1, or 440.15.1a, Florida statutes. And this is the case for which the teams are prepared to present argument before the court today. Thank you all so much.
All rise. First District Court of Appeals now in session. All who have business before this court draw near to May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning. I'd like to welcome you all to the First District Court of Appeal for the finals of the Moot Court argument. We have one oral argument scheduled for this morning. The case of Bankston County Sheriff's Office versus Jane Doe on behalf of decedent John Doe. Counsel ready to proceed? You may approach. Counsel will allocate 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal? Yes, 1 minute. So noted, Madam Clerk. Will you please identify yourself as well?
Yes, my name is Samantha Lee, counsel for the appellant.
You may proceed, counsel.
May it please the court. Good morning, your honors. My name is Samantha Lee, and I, along with my co-counsel, Chrissy Michelle, represent the Bankston County Sheriff's Office, the appellant in this matter. At this time, we would like to reserve 1 minute for rebuttal and split our time equally. Ms. Michelle will be explaining why Mr. Doe's death was not a compensable injury. First, I will be explaining why Dr. Don Wright's medical opinion testimony was inadmissible under Chapter 440 and because it does not amount to competent substantial evidence. Section 440.135E expressly limits the admissibility of medical opinion testimony to that of an independent medical examiner, expert medical advisor, or an authorized treating provider. The only part of Dr. Wright's testimony that was admissible was his testimony as to Mr. Doe's cause of death because, as this court stated in Office Depot v. Swaycata and Rente v. Orange County, it was limited to a factual report of the diagnosis.
Counsel, why wasn't Dr. Wright's testimony admissible as the testimony of a medical examiner?
Your Honor, his testimony as to Mr. Doe's cause of death was admissible. However, what was inadmissible was his testimony as to causation, where Mr. Doe contracted COVID-19 from, because that was in the form of an opinion. Under Section 440.135E, he must have been an independent medical examiner, expert medical advisor, or an authorized treating provider in order for this testimony to be admissible.
Well, I'm not understanding the distinction. Isn't the cause of death an opinion too, and not a medical opinion?
Your Honor, when Dr. Wright performed the autopsy, he was looking for Mr. Doe's cause of death. He wasn't looking for where Mr. Doe contracted COVID-19 from. So he determined that Mr. Doe had passed away from ARDS due to COVID-19. However, he did not attempt to determine where he contracted COVID-19 from. That was a separate issue.
So you would concede that the ARDS cause of death is what was properly admissible?
Yes, Your Honor, that is admissible.
Thank you.
Dr. Wright was not an authorized treating provider because BSO did not authorize him to treat Mr. Doe for the purpose of this dispute. Additionally, the JCC did not and could not have appointed Dr. Wright as an expert medical advisor because one will only be appointed when there are differing medical opinions supporting a claim.
How do you think in a death action like this one, how would a claimant establish causation when there's a death? Because obviously there's not, IME can't examine the corpse. So what's the alternative?
Your Honor, in this case, the claimant could have designated a different physician to look at Dr. Wright's medical records when he performed the autopsy to determine causation. And if they were to do that, they would have had to notify BSO within 15 days of their selection of an independent medical examiner. So Dr. Wright could not have been an independent medical examiner. However, the claimant could have selected a different physician to observe Dr. Wright's records from the autopsy that he performed, looking specifically for causation and not simply cause of death.
But what would the medical examiner have put in his records? I mean, he's looking at the body and he concludes, okay, this person had ARDS and COVID, and cause of death is ARDS secondary to COVID. a doctor, another doctor coming in, just reviewing his records and then saying, yeah, I've read the records, and because I'm designated as the IME, I can now opine that as to causation? Is that what you're proposing?
The claimant could have done so in this case, and the statute, section 440.135E, and the entire statute, section 440.13, explicitly lays out the ways in which medical opinion testimony could be admissible. There was no dispute at the time that Dr. Wright performed the autopsy, so he could not have been designated as an independent medical examiner, which is why the claimant must have designated a different physician as an independent medical examiner. And the statute is clear that that was something that they could have done, but they failed to do so here.
So you're saying they would needed to have had a second autopsy by someone designated as an IME?
No, Your Honor, not a second autopsy. However, someone to look over Dr. Wright's medical records of the autopsy that he performed.
Counsel, how do you distinguish this case from Stokes versus Schindler Elevator Corporation, which is a 2011 opinion from this court, where we found that the pathologist's expert opinion testimony was evidence demonstrating causation?
Your Honor, in Stokes versus Schindler Elevator Corporation, the claimant's injury was already found to be compensable. His injury, his ankle injury, was found to be compensable, and the surgery, the subsequent surgery, was compensable as well. However, when he died after that ankle surgery, that's when the medical examiner's testimony was admissible to determine whether his cause of death was from the surgery that was already compensable. Here, there was no finding of compensability at that time. And in the alternative, even if this court determines that Dr. Wright's testimony was admissible under Chapter 440, it still cannot come in because it does not amount to competent substantial evidence.
Why can't Dr. Wright be considered or designated as an IME?
Dr. Wright cannot be designated as an IME because he must have been designated as one within 15 days after the examination were to take place. Additionally, Dr. Wright could not say with any ounce of certainty where Mr. Doe contracted COVID-19 from.
Could he rely, though, on the CDC guidance or whatever you call that, the rule or whatever, the directive, and the CFO's directive?
Your Honor, my co-counsel will elaborate on this issue further. However, the claimant was required to prove the claim was compensable by introducing medical testimony. And without Dr. Wright's medical testimony, no other medical testimony exists here to support a finding of compensability.
Sure, but could he just say, like, I reviewed, I'm aware of the CDC guidance and the CFO's directive, and I'm just telling you in my testimony that this is what that guidance says. Could he do that?
Your Honor, I see my time has expired. May I briefly answer your question and conclude? Sure. Thank you. In order for his medical opinion testimony to be admissible, the statute is clear that there is only 3 ways for his testimony to be admissible. So if he was not an independent medical examiner, expert medical advisor, or an authorized treating provider as required under Section 440.135E, no, his testimony would not be admissible by relying on the CFO directive or any other evidence. For the foregoing reasons, this court should find that Dr. Wright's testimony was inadmissible. Thank you.
Thank you, counsel. You may proceed, counsel.
Good morning, Your Honors. May it please the Court, as my co-counsel stated, my name is Christy Michelle, and I too represent the Banks and County Sheriff's Office. this court should reverse the JCC's final order and find that John Doe did not suffer a compensable injury because the claimant failed to establish that John Doe contracted COVID-19 within the course and scope of his employment pursuant to Florida Statutes Chapter 440, or that John Doe is at a substantially greater risk of infection from COVID-19 than
But doesn't the nature of a paramedic's employment substantially increase the risk of exposure to COVID-19?
Your Honor, absent any additional testimony to establish this, the claimant was required to provide, by preponderance of the evidence, that by the nature of John Doe's occupation, he was at a substantially greater risk of COVID-19 infection. However, this court has analyzed exposure to viruses such as herpes and hepatitis under the same framework as that of claims based on exposure to toxic substances. These claims are governed by Section 440, which creates a presumption against compensability. Of the three factors that a claimant would need to prove in order to rebut that presumption, the only one at issue here is occupational causation. Section 440.09.
Are you conceding that the virus is a toxic substance or some sort of?
Yes, Your Honor. The virus would count as a toxic substance based on this court's analysis of viruses in the past. And under Section 440.01, the burden is on the claimant to provide specific proof of occupational causation. Moreover, where the injury is not readily observable within the course and scope of that employment, the testimony as to causation must come in the form of medical testimony. Medical testimony must include substantive statements that exposure to the injury-causing substance occurred within the course and scope of the employee's work. Additionally, in Lloyd, Stokes, and Prendville, this court stressed that medical testimony regarding causation must be given to a reasonable degree of medical certainty.
Why isn't the CDC directive and guidance in the CFO's order enough to for the claimant to meet his burden?
Your Honor, the CFO directive was issued after John Doe's injury, and within the workers' compensation scheme, the date of injury or death is the date that determines which law applies. So
are you suggesting that the CFO's order is a law?
It is not a law. However, it operates in a similar sense as a statute. And
on what basis? Is there a statute that makes the CFO's directive relevant to a work comp case? You said it's equivalent to a law. This is a work comp claim, and you're talking about. I'm just asking why is the CFO's order directive relevant at all in a work comp case?
The CFO was given authority to create special provisions for first responders such as John Doe in the event of an emergency. However,
right, isn't that in the context of his position as a regulator of firefighters, as the fire marshal, and not in the context of work comp cases?
Yes. However, the CFO was approved and went into effect shortly after John Doe's injury. However, regardless, it would not be applicable in this case because the workers' compensation scheme is one entirely created out of statute.
Well, you're analyzing this under the 440 under comp. Why was there error in applying the 112-1815 presumption that a paramedic or firefighter, law enforcement gets? Why was that wrong?
The 112.15 provision reduces the burden of proof for the claimant, and because John Doe is a first responder, the claimant did have to prove their case by a preponderance of the evidence. However, that still hasn't occurred in the present situation. Additionally, under 112.1815, the precedent allows it to be read in paramateria with statutory language of Section 112, which would look at an occupational causation test for
Well,
the injury.
if we're using 112, why does the Lake v. Irwin Yacht case cited in your brief apply at all then?
This court had acknowledged that it was an error to apply a less exacting standard that was originally produced in the Lake v. Irwin test, and instead said that the occupational causation standard of 440 was most applicable to instances where an individual was exposed to a toxic substance. And this court in Titusville had stated that medical testimony saying an injury most likely occurred within the course and scope of an employee's work was not compensable because it was not offered to a reasonable degree of medical certainty. And similarly here, Dr. Wright states that it only sounds like a reasonable explanation that John Doe was exposed to COVID-19 within the course and scope of his employment and his conduct with Anna Drucker. But shortly after, he states that there's no real way of knowing whether John Doe's injury was the result of his contact with Meg Doe or contact with Anna Drucker.
Are you suggesting, though, that the claimant couldn't establish, the claimant, the decedent's wife, couldn't establish causation via fact witnesses, people who were there, and say, well, here's the series of events that occurred, and from which the JCC could infer causation? Is that not allowed?
No, Your Honor. The statute is clear that absent readily observable injury within the course and scope of employment, medical testimony as to causation needs to be offered. And here, Dr. Wright merely presents occupational causation as a possibility, but does not determine one way or another whether John Doe's injury was more likely than not the result of his contact with Anna Drucker.
Well, how would medical testimony, what would that look like? I mean, what are you suggesting the claimant should have done to present causation in an instance where the claim is that the person died because of a virus and after being exposed? I mean, he's already dead.
Your Honor, I see that my time has expired. May I briefly answer your question? John Doe, Dr. Wright could have said that based on what we know from the CDC's guidelines about the incubation period and the timeline between when he contacted Meg Doe or Anna Drucker and his injury, we can conclude that it's more likely than not that John Doe contracted COVID-19 through his employment. However, that is not what we have here. Instead, Dr. Wright states that there's no real way of knowing whether John Doe's injury was the result of his contact with Anna Drucker through his employment or through his contact with his grandmother, who lived in the same senior facility as his patient who subsequently died of COVID-19. And for the aforementioned reasons, Your Honor, this court should reverse the JCC's final order and find that John Doe did not suffer a compensable injury. Thank you.
Thank you, counsel. You may proceed, counsel.
Good morning, Your Honors, and may it please the Court. My name is Jillian Ginger, and my co-counsel is Emily Means, and together we represent the appellee claimant, Jane Doe. As you've heard, there are two issues before the Court today. I will discuss whether JCC properly admitted Dr. Wright's testimony, and my co-counsel will discuss why Section 112 controls Jane Doe's claim. The JCC properly admitted Dr. Wright's testimony for two primary reasons. First, Dr. Wright's testimony is admissible as fact testimony.
Well, counsel, was Dr. Wright ever officially designated as an IME?
He was not, Your Honor. Dr. Wright's testimony is admissible as fact testimony. And Dr. Wright's, any inadmissible medical opinion given by Dr. Wright was harmless error.
Well, isn't, as far as the fact testimony, isn't the cause of death, that's an opinion. I mean, a layperson couldn't render a cause of death, could they?
That's correct, Your Honor. Here, Dr. Wright, under the Gutierrez v. Vargas precedent, under the Rente precedent, Dr. Wright provided a medical, Dr. Wright testified to the results of his autopsy. And this was, this is allowed in the Gutierrez precedent, and it's also allowed by his statutory duty to perform an autopsy. Dr. Wright testified in the record on page 3. Dr. Wright said that Dr. Wright presented the evidence that's in the record, which is allowed by Rente, which allows a doctor's to present his diagnosis, which is what he did here.
As far as your harmless error argument, I mean, it caused the claim to be paid, the testimony, but for Dr. Wright's testimony, the claim would have been denied. Would you agree?
I would not agree, Your Honor.
You wouldn't agree that you think there's enough evidence? Why would there have been enough evidence even if we didn't have Dr. Wright's testimony then?
Your Honor, the evidence in the record is substantial. There's a lot of fact evidence in the record. The Battalion Chief Wolf testified, and to the facts of the case and to the timeline. And John Doe was exposed to Anna Drecker, and within 24 hours, the timeline of the evidence is substantial here. So he was exposed to Anna Drecker, and then whenever he saw his grandmother, after 24 hours after seeing his grandmother, he tested positive for COVID-19. Incubation periods and traditional incubation periods would suggest that is not it takes longer than 24 hours. And my co-counsel will discuss more of that. But that evidence is
Getting back to Dr. Wright again, Counsel Doe, what made Dr. Wright confident to render an opinion on the causal connection between the claimant's exposure and death?
The Rente precedent here and the Gutierrez precedent says that a doctor may give evidence, may testify to the medical performance that he has performed on a claimant, and that's what Dr. Wright did here.
Is an autopsy a medical performance or a medical procedure?
Yes, Your Honor, it is. The doctors perform medically whenever they've basically applied their own medical knowledge, and pathologists have been. It's been held that pathologists are medical doctors and perform medically. So, but also he performs due to a 406.11 of the Florida statute says.
But did Dr. Wright treat COVID patients?
No, Your Honor. Dr. Wright's a medical examiner, but he is competent to give this testimony here. And he was Chapter 406.11 of the Florida statute says that a medical examiner of the district in which the death occurred shall perform an autopsy as he deems necessary when an individual dies due to a disease constituting a threat to public health, or when an individual dies due to a disease or toxin resulting from employment. And that's exactly what happened here. John Doe was exposed to a very new disease, which was a threat to public health, and then he also died within days resulting from employment. And so Dr. Wright performs the autopsy pursuant to his statutory duty to perform that autopsy. And so Dr. Wright performed an examination within the scope of his duties as a medical examiner of the county of the state of Florida, and he then provided fact testimony in line with that statutory duty.
So do you make a distinction then between a medical opinion and, I guess, testimony based on one's training and experience? Is that the distinction you're basically making with respect to Dr. Wright? That is, are you arguing that Dr. Wright didn't offer a medical opinion, that he only offered medical testimony based on his training and experience? He looked at the body and did whatever blood test or whatever and concluded that the cause was COVID. Is that the distinction you're making?
No,
on admissibility.
Right. It is our opinion that Dr. Wright provided a medical opinion. He did say that John Doe died from COVID-19.
But how does that not kill your argument then? I mean, if you're conceding that it was a medical opinion and the statute says that there are only certain people that can offer medical opinion, and it doesn't sound like Dr. Wright fits into any of those categories, what's that response? I mean, how do you get around the statute that says it's only an IME or an EMA or the treating provider?
Right. Your Honor, Dr. Wright, the only medical opinion he gave was that John Doe died from COVID-19, but that's not at issue in this case. The
Well,
issue
Counsel, wasn't Dr. Wright's testimony based on speculation when he gave answers like, that sounds like a reasonable answer, and maybe the claimant got it from Meg, maybe he gave it to her, maybe she got it otherwise?
Your Honor, those are not opinions. Dr. Wright did not give opinions in those answers. The only medical opinion he gave is that John Doe died from COVID-19, and this is harmless because it is not what is at issue in this case. There's other evidence in the record that John Doe died from. We know that John Doe tested positive from COVID-19 from a different source. Dr. Wright provided admissible fact testimony by testifying to the results of his autopsy, which is allowed by the Rente precedent. And there's other evidence in the record supporting that he died from COVID-19. But what's at issue is from whom he contracted it, and Dr. Wright's testimony does not provide information on that. The other medical testimony that he gave was pursuant to his fact testimony. And so it's important here to remember that the JCC functions to hear all of the evidence. They are in the best position to make a determination, and and they did that here. There is evidence in the record, which my co-counsel will discuss more. But in conclusion, Dr. Wright gave admissible fact testimony based on precedent, and the Gutierrez precedent and a statutory authority to perform that autopsy. And so for these reasons, we ask the court to affirm.
Thank you, counsel. You may proceed, counsel.
May it please the court. As my co-counsel stated, my name is Emily Means, and I will be discussing the statutory authority for Jane Doe's claim and her ability to meet the evidentiary requirements. Your Honors, the JCC correctly awarded death benefits to Jane Doe, and today I will walk you through 2 reasons why overturning this verdict would lead to injustice. First, statutory construction mandates the governance of 112.1815. And second, the JCC could reach the same conclusion under Florida Statute 440.02.
With that said, does the claimant concede that she did not meet the clear and convincing evidence burden under Section 440.151?
No, Your Honor. That is our alternative argument and my second point. Would you like me to start with that?
You may proceed.
Under Statute 440, Jane Doe must show by clear and convincing evidence that John Doe was exposed to a toxic substance and the level to which he was exposed can cause an injury or disease. And the record fully supports that. As my opposing counsel stated, it can be seen as a toxic substance based on our precedent and based on the fact that it's not limited to a fungus or a mold based on the statutory language.
Well, Dr. Wright said that toxic substance normally refers to chemicals. So how was there competent substantial evidence then that this virus, which is not a chemical but some sort of biologic entity, how is that a toxic substance?
Your Honor, when looking at the statute specifically in 440.02, as I said, it's an example is fungus or mold, but it's not limited to those things. And when we look at what toxic means, for example, Blacklaw's dictionary says that it has the producing effect of a poison, something that causes damage to living tissues, has a fatal effect on the human body. That's exactly what COVID does. COVID is the first impression of this court to talk about it in terms of a toxic substance, but COVID is a first impression to this world. Our statutes don't consider COVID when it was written by our legislature.
Is it the first time we've had a virus, though?
No, Your Honor, but this is the first time we've seen it as a pandemic. It's the long-standing duck test. If it looks, swims, and quacks like a duck, it's a duck. And if it looks, acts, and kills like a toxic substance, it should be treated as such by the law.
Sure, but it also walks, talks, and was it quacks? I forget. Like a duck in the sense of isn't it like an ordinary disease of life? I mean, isn't it affecting everybody? I mean, what makes your client specific or your client's field specific? Or why is this not just an ordinary life type of disease?
Your Honor, it's the appellee's position to not analyze this case specifically under the occupational disease statute that looks at whether or not it's an everyday disease of life. An occupational disease, when Florida jurisprudence talks about it, is something that's gradual and imperceptible. That's not what COVID is.
You're saying we shouldn't rely on the statute text of defining occupational disease?
I'm sorry, will you repeat your question?
Are you saying we shouldn't look at the definition in the statute for occupational disease?
No, the statute does define occupational disease. However, when it's applied, and in our case law, the claimant can recover under occupational disease or under toxic exposure. And this fits the toxic exposure route of compensation. Additionally,
For clarity purposes, is the appellee's position on appeal that this is an occupational disease case, not an exposure case?
no, Your Honor, it's the opposite. The appellee's position is that he was exposed to a toxic substance of
What's the
COVID-19.
significance of each characterization?
So an exposure case looks at whether or not they were exposed, to the level of which they were exposed, and whether or not it can cause an injury or disease that was sustained by the employee. Occupational disease looks at whether or not you're at a certain higher risk for a certain disease based on your employment. And specifically under the statute of 112.1815, the toxic exposure theory reduces the claimant's burden of proof.
Well, I understand your argument under that. What, though, would be the result if we think that this should be analyzed under 440 and the Lake v. Irwin Yacht test? How does your client win in that situation?
Your Honor, when we look at our case law, specifically with COVID-19 and a pandemic, we have to look at it within the context of the situation, and it's distinguishable from what we've seen. When we look at the evidence in the case, we have the fact that he was exposed to COVID-19. We know this because the battalion chief said that they needed to quarantine for 14 days and test for COVID. You don't do that if you're not exposed to COVID-19. And the statute directly says if you are exposed to something that can cause an injury or disease. We have that exactly in this case. Additionally, my opposing counsel advocated for Titusville versus Taylor. And in that case, they never even tested the workplace if there was a fungus present. It was more of a testimony of what kind of environment the fungus would live in, and it was a similar environment as to the workplace.
But given the claimant could have just as easily gotten COVID off the job from his grandmother as getting it from the patient that he was trying to treat, how is the burden of proof satisfied?
Your Honor, there is a substantial difference between contraction and exposure. Whether or not someone actually contracts COVID-19 or any disease for that fact, there's a lot of unpredictable factors involved, but it's whether or not he was actually exposed on the job. The statute requires a causation element in that it can cause occupational disease by clear and convincing evidence. In the dissenting opinion of Gibson, it says that clear and convincing can be established by circumstantial evidence. We have that here. He was exposed. He was told to quarantine 3 days later. It took them 3 days to tell the rescue team that they rescued a COVID-19 positive patient. He did visit his grandmother. However, that visit, as my co-counsel stated, was less than 24 hours before he tested positive. That does not align with the CDC guidelines of 2 to 14 days. He was exposed to COVID-19, and that exposure absolutely can cause COVID-19.
Counsel, help me understand, and I've been struggling. You're making a distinction. You're saying exposure to a toxic substance is a separate, independent basis for recovery, separate and apart from occupational disease. Is that what you're saying?
Yes, Your Honor, I see I'm almost out of time. May I answer your question?
Oh, sure. And I have a follow-up to that. Oh, maybe I'll ask.
Okay.
So what I want to know, help me understand. I thought that the basis for this claim, correct me if I'm wrong, is under Chapter 440. It's a work comp claim, right?
It's the appellee's position. It would be absolutely under 112.
Oh, great. So then under 112, point to me the specific provision in 112 that says that you recover work comp benefits under a basic toxic substance, separate and apart without any reference to Chapter 440.
Under 112.1815, it says that if you are exposed to a toxic substance to the levels to which you're exposed, can cause occupational disease by preponderance of the evidence. And that statute alone provides the route to compensation for a first responder that is exposed to a toxic substance. There's other provisions in 112 that talk about PTSD and things specific to a first responder that goes into different diseases that they are more susceptible to. And so when we look at which statute to apply in this case, we have the fact that a firefighter is named in the title of the statute. This was meant to protect him, and 112.1815 directly does that.
Well, but doesn't 2A1, it's really in the negative, that it can't be caused by exposure to toxic substance unless, and it has a bunch of stuff, including what you referenced. But it sounds like it's still a subset and exception to occupational disease that's in Chapter 440, which is, I thought, the ultimate basis for your client's claim. Otherwise, what are you talking about? Because the preponderance of the evidence standard, I thought, was to change it from the clear and convincing evidence standard that's in the occupational disease provision in Chapter 440. But you're saying, I don't want to deal with occupational disease at all in Chapter 440. I want to take advantage of this particular provision.
When it comes down to the unless standard, it's the rebuttable presumption of whether or not it actually came from work. And that's the carve out there from 440. And 440 does talk about both occupational disease and toxic exposure. It says that an injury in workers' compensation is an injury or disease that arises out of the course and scope of employment. When it comes down to it, 440 does allow you to compensate either for toxic substance or from occupational disease. Our case precedent shows us that you can recover solely on the toxic exposure theory, and that's what the appellees are arguing today. For these reasons, we ask this court to affirm.
Counsel,
Thank you.
before you sit down, I also have one final question.
You're good.
What evidence or legal authority is there to support the conclusion that COVID-19 is a toxic substance?
Your Honor, when we look at our statute and our case law surrounding toxic substances, we do not see something like COVID-19, but we do see things habitually that meet the same standard. This is exactly what the statute was intended for. If it's something that looks like a toxic substance, it should be treated as such. We've applied it to things like the sun. If you're exposed for the sun too long, you can get heat exhaustion. And if it meets those guidelines, it directly can be applied in this case. There's not any case law that says if you suffer from a pandemic, it's considered a toxic substance, but the statute says that it's included but not limited to a fungus or a mold.
Thank you, counsel.
Thank you.
You may, counsel. And counsel, we will extend your rebuttal time by an additional 3 minutes in view of the questions of the appellate, should you need it.
May it please the court. Your Honors, the law is clear. A physician's medical opinion testimony is inadmissible unless they are designated as an IME, EMA, or authorized treating provider. Under the Gutierrez framework, Dr. Wright's factual testimony as to his autopsy was admissible, however, his opinions were not. Additionally, under Section 440.091, where it is not readily observable that the claimant's injury occurred on the job, medical testimony as to causation must be presented. Without Dr. Wright's opinion testimony as to causation, this claim must fail. Thank you.
Why isn't is not the CDC guideline stuff, does that not count as medical evidence, I guess? Is that the position?
Yes, Your Honor, that is our position. There must be medical testimony from a physician to support a finding of compensability.
What about their, I mean, they conceded, but do you agree, though, that there's no distinction between, or do you agree that a doctor testifying based on his own training and experience still is medical opinion testimony?
Yes, Your Honor, and that is why, because he was not an independent medical examiner, expert medical advisor, or authorized treating provider, his medical opinion testimony is inadmissible.
So then why is his testimony about the autopsy admissible? If you're agreeing, you're going down that road, if you're agreeing that it's all medical opinion, if the doctor's testifying, how is not the autopsy evidence
Your Honor, under the Gutierrez framework, the testimony as to his findings from the autopsy, it's important to make a distinction between cause of death and causation. The testimony as to cause of death is not in the form of an opinion because it's factually based on his autopsy that he performed. However,
Based on his training and experience.
Yes, Your Honor. However, the testimony that it sounds like a reasonable explanation that he contracted COVID-19 from Anna Drucker and also that he could have contracted it from his grandmother, Meg Doe, that is testimony in the form of an opinion. And that is what is inadmissible here. Thank you.
Thank you, counsels, for your respective oral arguments this morning. You've all done an excellent job. This concludes our oral arguments for this morning. We stand adjourned.
Excellent job, everybody. Excellent. Usually when we do this live at the Workers' Compensation Convention, we take this time while the judges are deliberating to announce the winners of the various brief contests and the oral advocacy. Hi, Kath. Best brief was won by Team 10, Miami. There was a tie for second best brief, Team 18, Baylor, and Team 23 from Mississippi. So there was a tie there. The best oralist was also from FIU, Team 22. Michelle Sola was the best oralist, and how that's calculated is the total scores from the first two preliminary rounds on an individual basis. Whoever scored the highest there gets that award. And then, of course, our finalists, Team 17 and Team 18, and we will learn soon from the judges who won. I know I've conveyed this before, but of course these are sitting first DCA judges. The preliminary rounds were all done by sitting judges of compensation claims, probably about half from Florida, but half from other states, Louisiana, mostly I think in Mississippi. So this competition gives the students a really unique opportunity to be able to argue in front of real sitting judges who do the type of law that the problem is about. So it's my 20 years doing this has been a thrill. So I enjoy it a lot. So as you were coming in, we had all the awards out on the table. When the judges come back in, they'll offer some comments to you and then announce the winner. And then they'll hang around. Chief Judge Rowe is going to come down as well. She's going to give a little history of the court and be around for coffee and pictures. So congratulations, everyone.
What a fault.
Yeah.
You see this comma? This comma right here?
There's a commute that's like,
Please be seated. We have one point, Mr. Question. Go ahead. Again, thank you both for your respective oral arguments this morning. You've all done an excellent job. We've been asked to give you some helpful feedback regarding the oral arguments, which we will do shortly, followed by the announcement of the winner. I'm going to defer to Judge Tannenbaum to give feedback first.
Well, I don't think I'm not gonna go person by person. I'll give some general feedback. First of all, y'all did a fantastic job. I could not have done what you did today. And I've been on that side before, and I still don't think I would have performed as well under the unfair questioning that we did today. But overall, I think I'll make this as a general comment or a general observation that you can take with you as you become real lawyers one day. When you're doing advocacy, and, you know, you've put the trouble in, you've written the briefs, and you obviously the judges will have read the briefs, and you know, and they'll be prepared. Everyone's prepared in the room. Everyone knows that. The point of OA is not to redo what happened in the briefs. The point of OA is to either, if you have a strong case to begin with, is to really knock it home and not lose it. There used to be a saying that at least was taught to me, that you only lose a case in OA, you never win it in OA. I've been on the losing side of things. I refuse to believe that victory is ever out of reach into the last moment. Nonetheless, so if you have a strong case, it's a way to knock it home, and if you have the weaker case, it's an opportunity to really zero in on that one thing that you know the judges are wondering about, and just instead of pretending that it doesn't exist, go right there with it. You don't have a lot of time, and you want to make sure that you have the time necessary to address all the judges' concerns on that one issue. So with that said, as you approach your OA, and I know that there's structure to your competition, but overall, know what is your best point, what is the killer point on it, and go right to it. And or that's on the strong case side. If it's the weak side, then zero in right up front, go right to that, the weakest part of your argument. And when I say weakest part, I don't mean it's a secondary argument, it's the throwaway, you put it in there just in case. I mean, you know that your case could win, you know, it's going to turn on that issue, and you don't, there's some serious questions. Don't be afraid to just go right at it and address it right up front. At the same, and I'm not a huge fan of structure and templates and that kind of thing. So I don't know if this runs contrary to your competition rules, but don't feel like trapped by the structure of the rule, I guess, of the rules or whatever the formatting is or whatever your briefs were. If you have a particular issue, your section, make it your own. You know, issue 1 or issue 2. You know, make it your own, and then just really you want to grab the judges, because imagine your biggest fear is ultimately having a cold panel. That was, you know, you didn't have to worry about that today, but you want to provoke questions because you want to know what the judges are thinking, and you want to engage. That's why you're here. So overall, when you step to the lectern, be engaging, figure out have in your mind. And if you're the appellee, you have the advantage. You can already take the temperature in the room. You know where the panel is going. Sometimes you know, you listen to the questioning. If you're, you know, the second lawyer at the table, still listen, see where the judges are going. And then one of the most powerful things that you can do as a lawyer, as an advocate, is when you get up to the lectern and say, as Judge Lewis, as you were asking before, I would like to address that first. Because what you're saying is, I was listening, Judge, and I care about what you want to know, and I'm going to address that first. Anyway, so when you step to the lectern, have in your mind what you want to nail home, or the question you want to trigger, and just go right at it, and without any fear, and say, I want the questions, and I'm ready to answer them. And then also reflect that you have heard what the judges are asking, that you feel the room, that you're not on a script. Like, I'm going to tell you the lectern, and I have the thing that I want to say, and I'm going to say it regardless of what's happened before I got up there. So, but anyway, overall, great job. Thank you.
Thank you. Fully agree with all of Judge Tannenbaum's comments. I'll talk a little bit more specifically about how we scored at the things we were asked to look at, and how y'all did. I think everybody was good with the eye contact, and that's tough to do. Staring us in the eye. You were all good with that. You all spoke very clearly with great clarity. So we understood what you were talking about, and if you can understand me and Judge Lewis's Southern accents, you're doing pretty well. So, because sometimes we get what are you saying there? So I think we all communicated well, and appreciate that. The preview of the argument, I think that's good to tell us where you're going to go when you first get up there. And I think, let's see if I got your names right. I think Emily was real good, especially with that. Okay, here's the 2 points I'm going to talk about, and I'm going to go this way first. So that gives you kind of the roadmap of the discussion. Of course, as Judge Tannenbaum said, in real life, go where the judges want you to go and answer their questions. It's supposed to be conversational, but the preview is very useful and appreciative. I think you were all very clear, logical, persuasive. You were all very knowledgeable of the facts and your strongest cases. Clearly you focused on the issues on appeal and didn't go arguing things that were outside of the record or unnecessary, extraneous, and that's important. As far as time, we went over, I think, on at least 3 of your questions, and you all appropriately asked, is it okay to continue on then and answer that question? That should be directed, though, to the center chair, not to the judge that asked the question. He's the boss, or she, whoever's in the center chair, is the boss on time. And the judge might say, no, I think we've heard enough. The case is submitted, we're done, or we got a busy docket. Or I think you answered that question. So typically the center chair is going to give time to make sure that's answered. But it should be the questions of time or procedure in the courtroom are directed to whoever's in the center chair. The conclusions, I think they were very good and strong. I think all of you did a good job. I think it's especially beneficial, and I think Christy and Emily both did this to do more than just say we should win. Tell us just a very micro summary. Because this, then we should win. Because Dr. Wright was not medical qualified under the statute to testify, we should win. Fact by fact through there, whatever issue you're arguing. I think it's beneficial to give just a very little closing at the end. You've told us what you're going to tell us. You've told us, and then summarize it by telling us again that one last time. I think you're all, gave good responses to the questions. You didn't duck around or say, I'll get back to that or anything like that. I think you all did well with the poise and composure, and nobody, lost focus. And I know that's tough to do when you got a courtroom full of people. and of course, you're all respectful towards the bench and did a great job there. So I appreciate the arguments. I think you all did a terrific job, and I wish we could have a tie because I think you both did so well but no, I appreciate the argument, and thank you for all your hard work in getting ready, and thank you for your coaches too. You were both clearly well coached and well prepared for this. So make sure to thank your coaches for us too.
Thank you, Judge. I agree wholeheartedly with what my colleagues have said. I don't have that much to add. I thought they set forth everything. I would say this, though. What impressed me most is how well prepared both teams were. You can tell the issues were well researched. You were ready, you were prepared, and you were ready to go. You addressed all of our questions. You had what many may consider a hot panel. In other words, we wasn't just sit down, we had so many questions for you. But what I was impressed with is how you addressed each one of the questions. You didn't let it throw you off the base. You addressed the question, and you continued on with your argument. Many times we find that counsel, if you get a hot panel, they get asked a lot of questions, they get thrown off base. They can't pick up where they left off from. But you're able to continue with your arguments after addressing the questions. I thought both of you had great eye contact. Again, I was impressed with how well researched the issues were. We asked you questions concerning the case law. You recognized the cases, and you were able to distinguish the case or cases that we asked you about. This was a very interesting issue. It's a timely issue, and presented by these cases, and you both addressed them exceptionally well. I think the facts may have tilted one side more than the other, but both sides did an excellent job. As a former appellate advocate, I would say I didn't make the facts of the case. The facts were already made for me in briefing the cases. So you took the facts that you had and the case that you had, and you did an excellent job with that. With that said, for us, it was very difficult to select a winner because you're both winners. You wouldn't be a winner if you had. But the fact that you're here today speaks for itself. If you watch boxing matches, at the end of the boxing match, you have the announcer who gives the scoring, and sometimes you don't have a unanimous decision. You can have what's called a split decision. And I would say that you both did such an excellent job that for the panel, we had somewhat of a split decision as well, because you did such an excellent job. We thought it was so close, but in the end, it tilted just a little bit in favor of counsel for the appellants. But it was so close. You both did an excellent job, and thank you for your good work again. Is there anything else?
Can you tell us now that we've announced and we're not having any hometown bias or anything, what schools everybody's from? We're from FIU. Great. Well, thank you. Baylor. Oh, wow, great. Well, thank you for coming over. So that's great. Well, wow. And how many teams were in the 20 altogether? Wow. So, well, thank you for participating in the competition. And comp is, kind of a unique area. So, especially if you're all out of state trying to figure out our crazy comp laws. It's we've got the chief judge of compensation back in the back of the courtroom there, so you can talk to him about comp, and us too. So, but no, thank you both for participating in the competition in the unusual area. Oh, wow. That's great.
I wanted to, can I add, one thing that I had forgotten to include in my comments was for all of you, when you go into practice, and this has to do with conceding points, don't let a judge bully you into conceding or not conceding. You should have that in your mind in advance, like when you practice, when you have a team of lawyers and staff helping you prepare for oral argument one day when you're in a big law firm or wherever you are, or at the Attorney General's office, wherever. Know as you go through the arguments, know what you can concede without giving away your case. and know what you just absolutely can't concede, and know the difference and be able to explain why you can or cannot concede that. Anyway, I just know that, I mean, I think I did that to both sides, and it's not that anyone handled it wrong. I think it's an important thing to know when you go into OA. There are really just a couple nuggets where the battle is going to be won or lost, and all the other stuff is kind of throwaway stuff. You just got to know what you can give away and make the judge feel like you're working with him or her. You know, it's like, hey, we're reasoning together, and it's like, I'm so confident in my argument. I know one of the, I would say, like one of the weakest prosecutors I ever worked against when I was a federal PD and doing trial work. One of the weakest prosecutors that I dealt with was someone that didn't have enough knowledge of the law. And I won't say he or she was afraid to concede anything ever, because he or she did not know what they could give away, and so they gave away nothing, and it was very frustrating. It was very hard, and it's a poor reflection of preparedness, and that's not you guys. You know, you're obviously very well prepared, and as part of your preparation, just know the case so well that you know what things you can give away and what you can't, because then it really comes across even better, and it really it establishes a rapport with the judges in your OA, and it really comes across. It comes off really well. Just as a suggestion. Anyway, that's it.
I may add that both teams did a good job of establishing a rapport with the judges as
Oh,
well.
yeah, absolutely.
And addressing our questions as well. And, you know, as a former football player, you know, before the game, I always have my butterflies, and I'd be all a little nervous and everything as well. And I know both teams probably was a little bit nervous and both had butterflies, but you didn't show it. You did an excellent job presenting your respective oral arguments. Judge Bilbrey, would you have anything else to say?
Okay.
With that said, I understand coffee is made in the lobby, the rotunda area. Please join us for coffee in the rotunda. We are adjourned.
She knew I was going to come out.